Now, before I jump into this video, I need to make a huge shout out and thank you to the docket and to Plunder. First of all, the docket rang up the courthouse and got a copy of these two documents that I'm going to go through. He also handed those or shared those copies with Paula, Plunder True Crime, who has allowed me to grab copies of this off her directly, meaning that I don't have to wait till next week for my request with the courthouse for these documents. As you know, being in Australia, it's a bit hard for me to actually ring up and request documents, so I have to do it the slow way of doing an actual physical FOIA request. And of course, today is July the 4th in the USA, so there is a holiday, so it would have been a long wait for me. And I have to admit, I was looking forward to reading this particular document regarding the phone evidence because, as you know, from the very beginning I have been standing up for Detective Tagler and saying, in my eyes, she's a hero and she did nothing wrong. So, to Plunder especially, thank you so much, you utterly rock. Anyone who is not subscribed to Plunder True Crime, I can assure you that she is, in my opinion, the best creator on YouTube when it comes to true crime content. If you want someone who is going to always use verified sources, always act in a professional, ethical manner, pretty much always be the first with new FOIA documents and videos, and is definitely in this for all the right reasons, then you really do need to subscribe to Plunder True Crime. She's definitely my number one go-to when it comes for any information on cases, in terms of cases that I'm not myself covering. And of course, cases that I am covering, quite often I end up covering them because of her coverage. So I will of course tag Plunder in this video so that if you are not subscribed, then you can hop over and subscribe, and that way you can be first to find out so much about all these cases that she is covering. So back to this video. So this is the ruling that was made by Judge Carsten with regards to the request by Stearns' defence to have the phone evidence thrown out. Had this happened, this would have been a huge blow for this first trial that's coming up, the trial for the CSAM materials. So with this ruling and the ruling about the Google Drive, this pretty much means that Stearns' goose is well and truly cooked. I really cannot see a way that he is going to avoid a guilty verdict in this first trial, unless something goes seriously wrong. But it really seems like it is all done and dusted before we even start. I also have a one-page document which is the joint motion to continue. We know how that went. The judge said, I'm not going to grant this motion to continue, but you've got an extra week, meaning that the trial will begin on the 22nd of July. That will be all the pre-trial stuff with the jury selection and everything. And Judge Carsten expects that the trial itself, that the opening statements will occur on the 25th of July. I feel pretty confident that Allegedly Speculating will of course be streaming the trial, but I will confirm that for you closer to the date. As you know, I'm not quite in a position to be able to stream trials as yet. Hopefully by the time we get to the second trial later in the year, or whenever it ends up being, I will have managed to save up and get myself a MacBook so that I'm working on that as opposed to an iPad, and then I should be able to stream for you. But in the meantime, there's other creators who will definitely be streaming this trial. Okay, now before I get into these documents, I want to talk about Detective Tagler. Because from the very start, I put forward the opinion that Detective Tagler was a bit of a hero. I thought the way that she got Stearns' phone was pretty well done. It wasn't a big fight or anything. It was just a gradual asking for more, asking for permission. And I pointed out all along that they had probable cause. He'd been lying to them in interviews. I pointed out the exigent circumstances. They didn't know where Maddie was. She could have still been alive at that time, and they needed to find her pretty damn quick. And, of course, the other side of that was they knew he'd already factory reset his phone. They needed to get his phone to make sure that no more evidence was lost. He gave his permission voluntarily, intelligently, and knowingly. So from the get-go, I have been standing up for Detective Tagler and saying that, in my opinion, she's a pretty damn good detective. Now, in my previous video where I looked at the ruling on the warrants, I was kind to some of the other creators who had been pushing that Detective Tagler did the wrong thing, who had been pushing that, hey, these could get thrown out. The judge could rule in favour of these motions. Out of respect, I didn't name up the three main creators who were absolutely going out of their way for quite some time to utterly trash Detective Tagler and to utterly try and destroy her reputation. So it occurred to me this morning, when I looked at it that way, that these creators really went hard at Detective Tagler. And I had people coming into my videos who had watched their content basically telling me that Detective Tagler should be fired. And each time that occurred in my comments section, most of you will have saw, I stood up for her. And I said Detective Tagler did nothing wrong. But these creators kept bashing and kept bashing. And they were doing their best to utterly destroy her reputation. So I'm going to name them up because I believe that all three of these creators need to stand up, grow a spine, and actually offer an apology on their channels to Detective Tagler. Gavin Fish wasn't quite as bad as the other two, but he did use his position as a court reporter to convince people that Detective Tagler did do the wrong thing and that these motions may have been approved by the judge. Then you have guilty of crime. For some reason, she took a major dislike to Detective Tagler. Now, she eased off on that a bit, so I will give her credit for that. She eased off enough to actually go at Tagler, Acosta and Hunt equally. But she also was pushing the narrative that Detective Tagler should be fired. Detective Tagler was the worst detective on the force. And then the ultimate, Strategic Eyes, who used his position as being apparently a detective, who apparently has far more experience than Acosta, Tagler and Hunt, who was quite unequivocal in his statements about Detective Tagler, that she should have been fired, that she did not follow protocol, and that she did all the wrong things, and that it would be her fault if Stearns was acquitted. Like I said, I normally wouldn't directly name up channels when they do something like this. But when I thought about it, the thing that particularly frustrates me and makes me a little bit angry here is that we have a female detective. And I believe that a large part of the reason behind these channels pushing their narrative and questioning her and trying to destroy her reputation was because she was a female. I truly believe that had a male detective done exactly what she did, then they would probably be trying to stand up for him. This is a female detective who has worked really hard to get to the position that she is in. This is a female detective who got more information in her interviews with Stearns than anybody else who interviewed him. She, as far as I'm concerned, progressed the case further than any other detectives. Now we have to include Detective Acosta in this because he was part of that interview. But she was the lead detective in that interview, and we know that thanks to her, we ended up with an arrest. As a female detective in a field that used to be only for males, she's doing a damn good job, and we need to recognise that. It still is a very much male-dominated field to work in. And I have no doubt that she's probably copped a lot of discrimination in getting to where she's at now. She certainly is worthy of any higher positions that she may be wishing to go for. But it's going to be harder for her because she's female. That's just the way of it in her line of work. So I just want to give a huge congratulations to Detective Tagler, and I know she's not going to watch this, but I just want to say I have huge respect for this detective. She did the right thing, and now the judge has shown that that is, in fact, correct. Now, one more thing before I jump into these documents. The usual comment for anyone who's not familiar with my channel, that is my chihuahua snoring very loudly in the background. Both my chihuahuas have beds right here where I record my videos, and the moment I sit down and start working, as soon as they hear my voice, they come over, they snuggle in, and they go to sleep, and Amira starts snoring. So it is pretty much par for the course, especially in the cooler months. Okay, so let's take a real quick look at this motion to continue first. Again, thanks to Plunder and the docket for these documents. Joint motion to continue. In conferring with the opposing counsel, both parties move to continue this case from its present trial date of July 14th, 2025, which we know was then changed to July 15th, 2025. The grounds are that the parties are awaiting the rulings on the court on pre-trial motions. Additional pre-trial motions may be filed, and preparation for trial is contingent on these matters. Don't forget, this was originally filed on the 26th of June. The cut-off for pre-trial motions was the 30th of June. And we did have the defence file that last-minute motion to have newspapers removed from the courtroom. The parties request an in-court hearing to discuss new trial dates if the motion is to be granted in court. So we know that Judge Carsten denied the motion but said you've got an extra week. So now we have, well, actually an extra week because it was the 15th. So now we have the trial beginning on the 22nd of July with, like I said, probably opening statements on the 25th. So it does make sense now in terms of why both sides made that request, because as of the 26th of June when they filed it, they still didn't have a ruling from Judge Carsten on these matters that we are going to look at now. So this is basically a ruling on two motions that were filed. But of course, in the interests of efficiency, because they are both pretty much the same, Judge Carsten has put his ruling in one document. Order denying defendant's motion to suppress evidence obtained from unlawful searches of cell phone and motion to suppress evidence obtained from unlawful seizure of cell phone. This matter came before the court upon defendant's motion to suppress evidence obtained from unlawful searches of cell phone and motion to suppress evidence obtained from unlawful seizure of cell phone, filed February 6, 2025, and corrected April 29th, 2025. If you remember, they needed to correct it because they had their pages all out of order and they had done exactly the same with the warrant motion. The court, having reviewed the motions, the state responses, the arguments presented at the hearing on April 23rd, 2025, the court file, and being otherwise fully advised of the premises, finds as follows. Again, you can see that he has basically backed himself up by making sure that he conferred with other judges. This is not because he questions his own knowledge. Like I mentioned, he is or was, and I've forgotten which, a professor of law, with his specialty being case law. So obviously he could have done this in his sleep. He didn't really need to confer with other judges, but we have a major trial here, and these decisions impact on both this trial and the subsequent trial for Maddie's ending. I hate trying to say it. I hate trying to figure out how to say it. But basically, these rulings could have potentially impacted on what sort of sentence Stefan gets at the next trial. Because if the phone evidence and the Google evidence is thrown out, then that means that this first trial could have been a bust. And of course, one of the purposes of these pre-trial motions is to set the stage for an appeal should he be basically found guilty in the big trial, and should he actually be given a sentence of death. So basically, Judge Carsten has sought advice so that he is doing everything in his power to ensure that his decisions stand up to scrutiny should this case, or should the latter case, go to appeal. I'm hoping that we get just a little bit of that snark that we see coming out in Judge Carsten's rulings. We saw that in the warrant document the other day. So I hope there's a bit of that in this one, because this one especially, to me, is an important one because basically it shows that all these people who were out to destroy Detective Tagler, you were wrong. And please don't come at me for pushing that, because these people went at Detective Tagler for months. So I think I am well and truly justified in just pointing out that, hey, guess what? She wasn't the villain here. Okay, so motion to suppress evidence obtained from unlawful searches of cell phone. Defendant argues that the initial search of defendant's phone exceeded the scope of his limited consent. Specifically, defendant contends that while defendant consented to certain searches of his phone, the detectives exceeded the narrow scope of these searches. I noticed here that when he refers to defendant, he always puts it in capital letters. I guess that is just part of that is protocol with these things. But this is Stephen Stearns. I'd rather see he didn't get a capital letter when being referred to as defendant. Warrantless searches are, per se, unreasonable, subject only to a few specifically established exceptions. Katz versus United States, 1967. While consent is one exception to the warrant requirement, the state has the burden of proving that consent was freely and voluntarily given. Schneckloff, I like that, versus Bustamante. I know I've just butchered both of them, but sorry. 1973. Under Florida law, the state must show by clear and convincing evidence that the defendant freely and voluntarily consented to the search. Bailey v. State, 1975. When consent is obtained after illegal police activity, such as an unauthorised search or arrest, the unlawful police action presumptively taints and renders involuntary any consent to search. There is no bright line test for determining the scope of consent to a warrantless search. Such a determination is made on a case-by-case basis. Allen v. State, 2005. The scope of the search is generally limited to what a reasonable person would have understood to be the object of the search during the exchange between the person and the police. Jacobs v. State, 1999. And now Judge Carsten is going to add his professor hat to his judge hat. The state avers that defendant's argument depends on his misleading and incomplete recitation of the limited consent he gave Detective Tagler. The court agrees. On February 27, 2024, Detective Tagler and Detective Acosta interviewed defendant at his residence. The detectives were in plain clothes. Defendant was not in handcuffs. The defendant was free to leave. At 7:37 p.m, Detective Tagler asked permission to look at his Maps app in his phone. Defendant answered yes. Yeah, that's fine. Defendant willfully and voluntarily unlocked his cell phone and handed it to Detective Tagler. Detective Tagler soon thereafter asked permission to take a picture of his history. Defendant again consented. At 7:57 p.m, Detective Tagler asked again if defendant could unlock his phone so they could view its contents. Defendant willfully and voluntarily unlocked the phone. The detectives interviewed defendant a second time the following day. And yes, it was the following day because that second interview occurred sometime after midnight. I think it was about 12:15 or something. During the interview, Detective Tagler asked permission specifically to download his phone and asked defendant if he needed a warrant for his phone. Defendant again consented and provided the detectives his PIN number for his phone. And because he's such a narcissist, his PIN number, just like Jen Soto, was his birthday. No evidence suggests that at this point the detectives exceeded the scope of the search in any unreasonable manner. The evidence makes clear that defendant unlocked his cell phone and gave it to Detective Tagler on multiple occasions and unequivocally consented to them viewing map data and documenting his search history. Even after Detective Tagler asked if a warrant is needed, defendant nevertheless consented. Most importantly, defendant gave consent to law enforcement to download the cell phone and go through the phone. A reasonable person under the circumstances would understand the scope of the consent to include access to all contents that were searched in this case, including call history. So we go back to permission was given voluntarily, intelligently and knowingly, and there is also the objective reasonableness of it. A reasonable person would have understood what was going on. Furthermore, the evidence is clear that defendant was free to leave and the detectives interacted with him without coercive tactics. Consequently, the state has established by clear and convincing evidence the defendant freely and voluntarily consented to the searches and that law enforcement did not exceed the scope of defendant's consent. Motion to suppress evidence obtained from unlawful seizure of cell phone. Defendant contends that his cell phone was unlawfully seized by Detective Tagler for over 9.5 hours without consent or probable cause. To support his claim, defendant asserts that Detective Tagler made no attempt to obtain a warrant despite the availability to do so. The evidence demonstrates that Detective Tagler had probable cause to believe there was evidence of a crime contained in defendant's cell phone at the time of seizure. Probable cause requires a practical, non-technical probability that incriminating evidence is involved. Texas v. Brown, 1983. Probable cause only requires that the facts available to an officer would warrant a person of reasonable caution in the belief that certain items may be useful as evidence of a crime. As the state correctly points out in its response at the time of seizure, Detective Tagler knew that Madeline had been missing for over 24 hours. Defendant was consistently identified as the last person to have seen Madeline prior to her disappearance. Additionally, law enforcement had tag reader evidence that defendant was not being truthful with regard to his movements on February 26, 2024. Defendant also regularly used his cell phone to speak with Madeline. Consequently, the court finds that the facts available to Detective Tagler after consensually searching defendant's phone is evidence that would warrant a person of reasonable caution in the belief that the phone may be useful as evidence of a crime. Furthermore, Detective Tagler had exigent circumstances to seize the phone. The test of whether exigent circumstances exist is an objective one. United States v. Tobin, 1991. Whether exigent circumstances exist is a fact-specific inquiry that depends on the totality of the circumstances. United States v. Arellano Ochoa, 2006. The fear of imminent destruction of evidence must be objectively reasonable. State v. Data, 2022. Specifically, in determining whether state agents reasonably feared imminent destruction of the evidence, the inquiry is whether the facts as they appeared at the moment of entry would lead a reasonable experienced agent to believe that evidence might be destroyed before a warrant could be secured. Here, evidence shows that Detective Tagler had an objectively reasonable fear that the cell phone would have been later destroyed prior to securing a warrant. Detective Tagler, based on the answers of the defendant, had a reasonable belief that he had attempted to destroy cell phone evidence by factory resetting it at some point during the same day. The destruction of the cell phone was also likely more imminent after meeting with Detective Tagler and Acosta, given that he knew he was under suspicion and they showed interest in his phone. Because law enforcement was under the reasonable belief that destruction of the cell phone was imminent, and they had probable cause to believe there was evidence of a crime contained on the cell phone, Detective Tagler's seizure of defendant's cell phone was lawful. And I'm just going to reread that last sentence for the people in the back. Detective Tagler's seizure of defendant's cell phone was lawful. Accordingly, it is hereby ordered and adjudged that 1. Defendant's motion to suppress evidence obtained from unlawful searches of cell phone is denied. 2. Defendant's motion to suppress evidence obtained from unlawful seizure of cell phone is denied. Done and ordered in Chambers, Osceola County, Kissimmee, Florida, this first day of July. So to those channels who were determined to absolutely destroy Detective Tagler's reputation, when you offer your public apology, feel free to tag me in your video so I can actually see it. Now that brings us to the end of this video. This has been a rather satisfying video to do. As you know, from the very beginning, I was convinced that these motions would be squashed. And I had so many people coming at me and telling me I was wrong because experts on YouTube said that they would be upheld. I'm not a petty person, but I was busting a gut to defend Detective Tagler. So now I am glad that people can see that she was not at fault. And look, I should clarify for subscribers. I know I had subscribers come in here and pushing the whole idea that Detective Tagler should be fired. Detective Tagler did the wrong thing. You basically trusted individuals who gave their credentials, claiming that their credentials meant that they knew better than everybody else what the outcome was. So I certainly don't blame any of my subscribers who came in here and pushed the narrative of Detective Tagler being the villain here. You were led astray by other creators, basically. So I'm not having a go at anyone here. My issue is with YouTube creators using their platform to full-on attack a quite capable detective for quite a long period of time and essentially do a darn good job of trying to destroy her reputation. And I think it's a lesson for all of us there. That is, think logically and critically. Because a content creator tells you something, that doesn't mean they are right. I know I've certainly not been right on many occasions. The thing is, you need to listen to what they say and think logically and critically. And if you hear information that contradicts what they've said, then you compare what you've heard in a logical and a critical way. This has certainly hammered home for me the need for me to be very cautious in terms of what I am saying here on my channel, knowing full well that there are people listening to me and who may not take what I say as being opinion, or who may not listen to what I say and view it in a logical, critical manner and simply accept it without actually questioning what I'm saying. So I need to also be cautious when I am presenting my viewpoints to make sure that I am being clear that it is my viewpoints and that I'm not always correct. It also makes me even more determined to keep my professional background private, because it seems that it is so easy for people to use their professional background as a way of trying to convince people that they know better than everybody else. And you know what? Even if you are discussing something from a professional perspective, that doesn't mean that you're going to be right every time. So, on that note, thank you for listening. If you are new to my channel, please subscribe. And of course, also please leave a comment below. Thank you, and I will catch you in the next one.